Good morning, everyone. It's such a pleasure to have everyone here. It was not easy for us to be here today. I think we had different plans for 2020 event. It was supposed to be a major event in a partnership with ICLA, and but things changed, and we have to adapt. And that's the message that came from these times that we are living. And that's the idea, the main idea of the event that we are trying to conduct here. So it's a virtual event. We had some upsides in a virtual event, which is bringing a lot of very important people to speak and to share their knowledge with us, for which I'm very thankful. There's downsides for that event too, because we wanted to be together, and there are other aspects of the event that cannot be very well experienced. But next year we have to be optimistic and hope for better moments. So with the idea that we have to adapt, the organization committee of the event understood that we had to discuss what kind of change, what kind of legal innovation we are going to have in law, in construction industry, when we deal with our conflicts and our problems. So force majeure revisited was a way of bringing attention to, okay, we been in this situation for some time now. It's time to start to see what's going on. Wow. That feeling of desperation, it's already a little more calming. So the whole event will discuss in different aspects what's going to happen, what can we do, what's going to change, and what lessons we learn from this experience. There's one thing that is a hard topic to speak to, but I would like to address briefly, is the topic of gender inequality. We understand that we have some situations that this mark creates some boundaries and some challenges related to the situation of gender. And sometimes we don't realize, but we also are caught in this kind of situation, that your thought sometimes goes in a direction, and when you realize that gender inequalities is something that already happened. It's something we would like to say that IBDiC is very well committed to discuss this issue. But it has to be discussed in a very profound way, not in a way of building walls, but building bridges, trying to see if we can come up with solutions that brings this matter to attention. Well, we would like also to thank all our sponsors, Barros Pimentel Advogados, Hormigão Act, Giamundo Neto Advogados, Toledo Marchetti Advogados, Matos Filho Advogados. It was very important that you guys, even in these difficult times, went along with us in this event. Also our supporters, AACE, CR Brazilian Branch, CEBAR, IBRADIM, Curso Prático de Arbitragem, e Infra Women. Well, thanks a lot for the support. Some housekeeping. This event will be recorded for purposes. We are not sure yet if we are going to put this in our channel, depending on if it is possible and how to do it. But it's going to be recorded. There's some situations with the microphone of the panelists. Sometimes the panelists have control over their microphone and their camera. So even those who are not in the panel, they have the control over that. So be careful of not opening your microphone in the wrong time. the attendees don't have that option. The questions should be addressed in the Q&A session that is all open for all the participants. And with no more, I'm very happy to welcome my friend Marcelo Botelho de Mesquita, who is one of the best construction lawyers in Brazil and also one of the directors of the IBDiC, to moderate the first panel, which is a stellar panel, to say the least. Please go on and let's have a great event.
Thank you very much, Leonardo. Let me welcome you all to the first panel of the IBDiC Conference with ICLA, now in 2020, revisiting the right to contractual renegotiation in construction and in Brazil internationally. Let me congratulate you, Leonardo, especially, and Vitor Madeira for this event. One more year of the IBDiC Congress. It's an honor to participate once again, and greet all the participants and especially our IBDiC associates. Let me give you a brief explanation of what we are aiming with this panel. We're going to have a debate with our panelists, not just a presentation by them. So everyone who is watching us can also raise questions in the Q&A. We try to answer them more in the end of our panel, which focus in all the experiences that our panelists are having in this COVID-19 times. Let me say it this way. Since it began in January mostly, and after that in March, when the World Health Organization declared a pandemic to have taken place, a lot has changed with all of us and in our countries. We have now more than 24 million people infected in the globe. We have a total death number that is going to 1 million people. The pandemic, if I may add, is not only an unforeseen event, an unpredictable event, as the title of this event remembers. I may say that the pandemic is rather an inconceivable event for most of us and for our contracts. A lot has changed since the beginning, and a lot has changed also in the way that we deal in legal terms with the pandemic. When it hit us the first time, we had an assessment, and this assessment is changing. We're becoming more mature in legal terms about this whole situation. And our idea, as I said, is for us to share experiences, for us to know what are the legal framework that each of the panelist countries have to deal with such an inconceivable event. And also, which are the lessons that we all learn from this time? How can we evolve in our contract terms, in our contract drafts, in forms of contracts, and with the relationship with the parties in the construction industry? That being said, let me make a brief introduction to you of our panelists. We have with us, with great honor, Professor Paula Furgioni, who is a full professor and head of the Department of Commercial Law at the State University of São Paulo. She's a very experienced arbitrator, also in construction law matters, author of numerous books and a lot of articles. We also have Fernando Marcondes with us here. Fernando is the former president and founding father of the IBDiC. He's head of the infrastructure team of Elo Batista Advogados, Brazilian representative of the RBF, president of the Club Espanhol de Arbitrage, and arbitrator and a dispute member board. Ricardo Barreiro from Argentina is with us also. He leads the construction, engineering, and infrastructure team of Barreiro, Oliva, Luca Jaca, and Castro Advogados in Argentina. He's a fellow of International Construction Lawyers, co-chair of IBA, International Construction Project Committee, and has a huge experience in construction law. And Last but not least, we are honored to have here with us Mr. David Brown, who is a partner with Clyde & Co, based in Paris. He's a leading construction lawyer international and one of the top 3 specialists in France. He features on the FIDIC present list of adjudicators as well as the FIDIC French national list. David is also an experienced arbitrator and dispute board member. With that being said, let us start our panel and the first round of questions. I will start with you, Fernando. We have attendees mostly from Brazil, but we have people from abroad also. And I will ask you now for you to comment and give us a brief description of what happened in Brazil since March, since the pandemic hit us harder in the construction law industry. Did our works halted and were suspended? In general, they continue. And what is the legal framework that we have here in Brazil, Fernando, to deal with unforeseen consequences such as COVID in our contracts? And did our evaluation change it along these last months? Please, Fernando, give us your thoughts first.
Thank you, Marcelo. Thank you, everyone. Leonardo, thank you for inviting me again to be in the IBDiC conference. I think I am present in all IBDiC conference until now. It's a pleasure for me and an honor to continue with the group of IBDiC, a very specialized and very professional group, full of friends. It's very good to be here with you again. Well, Marcelo, answering your question, in Brazil, since the very beginning of the crisis, construction sector was considered as essential activity. So we didn't have an interruption of the works, except for a few days in the beginning until the scenario was defined. Nevertheless, a package of restrictive measures was implemented. So contractors had to reduce the number of workers in the work site. They had to redefine layouts of dorms, refectories, and bathrooms. They have to create even more rigorous rules about health and safeness, and also to provide even more extensive medical assistance. And they also have to deal with workers that got the virus, so isolation measures had to be implemented in the work sites or in new areas that had to be provided. It means rented, especially and exclusively for it. There is a case of one construction company, for instance, that had to isolate more than 5,000 workers since the beginning of the pandemic, with a peak of 1,500 people at the same time. And now, right now, they have almost 1,000 workers in isolation. And they had some casualties too, unfortunately. Those numbers are the total amount considering all the contracts that this company is performing right now. So if we share this number by several contracts, maybe the segregated cost will seem insignificant, but if people can say that the company must absorb it in its price. But when we put it all in the same basket, maybe we need to rethink that. And how to deal with this scenario? The most obvious framework that we can think about is force majeure. I think that there is a consensus that COVID-19 is a typical case of force majeure, since it is a fact and it's not given to the parties to avoid it or to stop its effects. Well, force majeure entitles the contractor to an EOT, as an extension of time, EOT as we used to say in construction market, but does not entitle the contractor to receive any kind of compensation for its losses. So the next step is to analyze the possibility of frame the COVID-19 as a case of excessive onerosity, as it is provided in our civil code, in Brazilian civil code. But at this point, we must face another issue. to characterize excessive onerosity, it's difficult for me to say these two words together. It's necessary that one party has an extreme disadvantage, and at the same time, the other party has an extreme advantage. This is the literality of law in Brazil. But the fact is that in most cases, we can easily see the first characteristic. That means the extreme disadvantage for one of the parties, but we cannot see the opposite. That means the extreme advantage of the other party. So we don't have the two elements that we need to characterize excessive onerosity. There is a doctrine that defends that we can presume that extreme advantage to the creditor exists based on the fact that if creditor would hire the same service or buy the same goods, considering this new scenario, he would pay much more for that. This doctrine claims that if the interpreter does not assume that extreme advantage is implied, the situations of excessive onerosity will be too little, which means that the legal protection will not be sufficiently wide. The problem that we have is that here in Brazil, this doctrine is not successful in the court so far. So, in my opinion, this is something that is not mature enough to sustain the discussion in the judicial environment. However, in arbitration field, the arbitrators are freer to consider the applicability or not of this theory. I think that is that for a moment.
Okay. Fernando, thank you very much for this insights. Now I would like to move to Ricardo, to Argentina. Ricardo, as Fernando pointed out, we had and have some drastic situations here in Brazil, but as a whole, in general, infrastructure work has been considered essential and are able to continue. I would like to hear from you, how is the situation in Argentina? The works have halted in general, they have continued in general. What is the framework, the legal framework that you guys have there? Are there, as Fernando told us, a right for the judge to adjust and adequate the contract? Which were the first impressions that you guys have in Argentina? And these impressions, they changed along these last months or not? Please give us your thoughts, Ricardo.
Thank you very much, Marcelo. Good morning to everyone. Bom dia a todos. Thank you very much to Dick, Victor, Leonardo, Marcelo Medina, Marcelo Mesquita for the invitation. It is a great honor for me to be once more participating in a panel of this wonderful conference. Congratulations for achieving the organization of this event under the current circumstances. The situation in Argentina, responding to your question, Marcelo, is quite different than what Fernando was describing in Brazil. I should say that perhaps the situation prior to the pandemic, prior to March, I would say, was also quite significant because the Argentine government had changed very recently, and Argentina was and still is involved in a quite severe economic crisis, which by itself impacted severely on the construction sector. And in this context, in this negative context, we had the impact of the pandemic, and in mid-March, the government basically ordered the strict lockdown, which extended under those strict conditions until mid-June, I would say. And construction was not, as opposed to what happened in Brazil, construction was not declared an essential activity. So most, if not all, construction projects were completely halted, both public and private projects, I mean. And basically, on top of that, the government ordered some measures aimed at forbidding the dismissal of workers and ordered companies to continue paying salaries. Of course, there were a number of government measures of relief that had to do with contribution of government to those salaries, discounts on taxes, extension of payment term for taxes, soft loans, and so forth. So the situation was quite complex. The industry was completely stopped. The chain of payment was absolutely disrupted, and companies were facing, and still are, for the most part, it's quite significant struggle. In mid-June, I would say, the situation started to be a bit better. In certain provincial jurisdictions, the activities of construction were reassumed because government understood that those provinces did not represent a major health risk. But in major urban areas or provinces that continue to suffer a significant impact of the pandemic, the situation continues to be pretty much the same, and contracts and projects are still completely interrupted. So this is the scenario for a perfect storm. You have an economic crisis, you have a health crisis, and a major disruption on the payment of change, on the chain of payment. Sorry. The first reaction, as Fernando was just saying, was to characterize the pandemic as a force majeure event. I think it has been the same case in most, if not all, civil law jurisdictions and in many common law jurisdictions as well. This has been an unforeseeable and irresistible event. And in Argentina, as it had the same case in Brazil and in most civil law jurisdictions, force majeure is a provision included in civil or commercial codes, but it's also, for the most part, included in contracts with regulations further establishing conditions and but on top of that, we should mention the impact that government measures had on the activity. Emergency laws and decrees that ordered basically the lockdown, ordered the continuation of payments and so forth, and which imposed significant financial and economic obligations and burden on contractors and principals and subcontractors. Basically, what Fernando was saying, the force majeure releases the party affected from performing the obligation, but does not provide for a compensation on additional costs. So you will typically get an extension of time, but force majeure by itself does not resolve the issue of higher costs. And the same thing applies to Argentina. So the new or additional legal remedies come into play. The problem with force majeure, as I see it, is that it's a concept that has been developed to address a specific event occurring on a limited area for a limited period of time. And the pandemic, the COVID-19 pandemic, has a completely different approach. It represents an event that has a global scale. All countries and economic sectors are impacted at the same time. There's an uncertainty of effects, consequences, and extensions, and we are coping with events as they occur. It's not something that we have to face in a moment and later deal with the consequence. We continue to live with this, and we don't know until when we will continue to live with this. The situation in Argentina is this, and it's no different, I think, than the general scenario in other Latin American countries. So Fernando mentioned that to deal with the excessive onerosity of the effects of the force majeure event, other legal remedies occur. The same are applied in Argentina. For frustration of purpose is one of those. If the contract basically cannot be continued because the pandemic made it impossible, then the contract will be terminated. And the imprevisível doctrine, the excessive onerosity Fernando was referring to, is also applicable. But you mentioned, you asked this question, and I think it's quite interesting, because the Argentine legal system also provides for a concept that we call the shared effort doctrine, which was basically developed after the crisis of 2001-2002, obviously to tackle with the financial struggle derived from the strong devaluation of the peso and the departure from the convertibility of the peso with the dollar, which created a massive disbalance in financial contracts. The concept here is that shared effort doctrine seeks to preserve the continuity of the contractual relationship in an equitable way for the parties after major disruption. This is the concept of this legal remedy. And again, we are still to see how this specific concept will be applied in construction contracts. Courts continue to be closed for the most part, or acting with very limited activity. But the discussion in the legal environment is that the equity readjustment of contractual provisions will be a sort of obligation under the current circumstances, and parties that fail to negotiate a solution will resort to courts, and courts with the experience achieved during the last 12 to 15 years will certainly do this and avoid contract termination and force the party to maintain the contractual relationship under a new equilibrium.
Perfect, Ricardo. Great panorama. And I think we all really do agree with you. The force majeure event, as is it in the law, and as we are taught, is something that applies to circumstances. And we never had that situation of a pandemic that is so long and with such big consequences. At least not me and not most of the people that I know. But now I would like to ask David a question here. David, I think you will have to work in double here as a British lawyer and also as a French lawyer. You can bring experiences and knowledge about the two systems. But now for this first round of questions, David, I would like to ask also to you how the pandemic has been seen, how it hit the French construction law industry, and which are the remedies that the French law provides to contractors and owners to deal with a circumstance like COVID-19. David wrote and published in the website of Clyde & Co. A piece of article with some outlines about the French legal systems and what can be done in COVID. This was made in March, and when we were talking about it, David pointed out to me, but Marcelo, when we wrote that, we were still young on coronavirus. March was a long time ago in the rush of the events. So David, give us your thoughts, and if anything changed from March to now, please explain us a little bit of what happened and the legal framework of France.
Thank you very much, Marcelo. It's a great honor and a pleasure for me to be with you all today. And I'm the first of the ICLA speakers. There are several of us. The association will be explained a little bit later on in the event, so I won't say much more about that for the moment. But if you don't mind, young man, Marcelo, I'm not a British lawyer. There's no such thing as a British lawyer. I'm an English lawyer. Don't forget that the Scots have a slightly different system. There are different regulations for coronavirus in Scotland compared to England. And perhaps Northern Ireland has slightly different ones. It's all very complicated on that relatively cold and windy island up there. But I shall try to stick to purely English things when I come to them a little bit later on. Anyway, let's get back to civilization and to France, if we can. Yes, like everywhere else, a lot of construction activity was very heavily affected from mid-March. And to some extent, especially the public contract activity really froze for several months and has been coming back to life in the last couple of months. I just wanted to focus briefly on one of the two biggest projects here, which is the Greater Paris Metro. We're going to, in the next few years, we'll have an extra 200 kilometers of automatic track, 68 stations. Hopefully quite a lot will be ready for the 2024 Olympics and Paralympics. It's already pretty tight, and COVID's not really helping that because the whole works was suspended on the 12th of March. They've come back to life quite recently. If I opened my office window, you'd hear them working in the otherwise very quiet street down below, so I won't do that. We had an official state of what we call a health emergency that ran on until the 10th of July that really slowed down activity very seriously. So what did the French legislators do about this? Well, the government declared pretty early on that this was a case of force majeure, which will not surprise many of us on the call. And then they brought in a whole range of provisions. So that means that there's effectively a suspension until for several months of the contract periods, and therefore of protection against delayed damages, time limits for the performance of obligations, and any possibility of terminating contracts were effectively suspended for several months also. But it's not, coming back to that major project, what I understand is that the leading players all sat down with the authorities and have carried out between them some serious renegotiation of contract terms on an amicable basis. But of course, French law, as I think many of you will know, already has provisions for renegotiation of contracts in situations where an event such as this pandemic makes performance, and the term is the one we've already heard from Fernando and Ricardo, excessively onerous. And I don't think that French law has the same position as Brazilian law. You don't have to have one party who's really benefiting from it. It's just the notion of one party really suffering from the situation. What is interesting is that this was really a provision that applied to public works contracts, but was brought into private works contracts with a thorough revision of the Civil Code about 4 years ago. And what it means, not that many of you will be surprised, is if the parties cannot themselves agree upon the terms of a renegotiation or adaptation of the contract, then the matter can be sent to the court, and the court will do it. Now, I'll come back to what an English lawyer thinks of this, because this is not something which, a notion that has really crossed the English Channel at all. However, this is a possibility that can be excluded by contract, which is interesting because there are some real doubts whether it's going to be very effective where you have fixed price contracts, because a fixed price or an invariably priced contract, it has already been considered by certain French courts to exclude that provision. So it's not quite far, not really very clear yet how far that is going to affect matters. And I better stop there, otherwise I'll get into English law and I'll be on for hours, Marcelo.
Okay. Thank you very much, David. Now I would like to move to a more dogmatic view, a more academic view of all these issues, and ask Paula, who is one of the greatest professors that we have here in Brazil in commercial law. She's a very experienced arbitrator and deals with a lot of issues regarding unforeseen delays and all these remedies, about some trends that are happening in Brazil. We are seeing, Paula, some theses that are popping up in Brazil, academic theses for the last years. They say there is a principle of contractual justice. There is a principle of a balanced contracts, a principle of equilibrium in contracts. Some of them even say that these principles are upheld, are sustained by our constitution, which would demand contracts to be equilibrated, to be balanced. And also some of those theses say that the parties cannot waive their remedies provided by law to have a judge intervening their contract to balance the contract, to adapt the contract. Well, by the other hand, our construction law industry is, I think, hallmarked by some contracts and some forms of contracts that, by nature, the parties abide and the parties waive their rights to such remedies. To give an example, the Silver Book of IBDiC that is used a lot here in Brazil, the EPC contract, has a specific clause that denies to the contractor the right to extra costs or to claim extra costs in view of unforeseen conditions. With all of that, I would ask you, Paula, to comment how the courts are seeing these trends. Is the right of these remedies or the rights to ask for a judge to intervene in the contract is something that the parties will be able to waive. These EPC contracts, how they're going to be and how are they being upheld in court, and how is this trend in Brazil of more power to the judge to intervene in the contract is being discussed in the academic forums. I think you're in mute.
I do this all the times. Good morning, Marcelo. Good morning to everyone. And I would like to thank you again, you, Fernando, and Leo, for this invitation. I'm very honored. I'm very proud to be here. So, well, in the first moment, there was chaos, terror, and panic here in Brazil, okay? So I think all over the world, we had some very populistic theories and ideas. Let's break down all the contracts. Well, we were young at that time. And I must say that courts, really, state courts, really did their job, because they were called before arbitration. So, and they gave a lot of injunctions, and they tried to curb opportunism, and I should say that they did their job. The first point here in Brazil is that we have to put apart consumer contracts and business contracts. We are talking about completely different things. So some theories that, okay, you may base on a consumer code, or some consumer judges would here are not applied in commercial contracts. And this is very strong here in Brazil. We have specialized business courts, as we all say. We have specialized state courts, business state courts. Here in São Paulo, we have specialized judges, and we have arbitration. And our courts respect arbitration. So I should say that the general idea, or the general situation here in Brazil is quite good. I mean, I follow state court decisions very hard. And I should say that decisions are trying to curb opportunism. Let me see. About the law. You asked me about the law. Here we have, there are a lot of theories. As you said, I'm an arbitrator and I'm a professor, and I used to be a business lawyer. So I will try to be very practical about it. We have a lot of theories, a lot of articles, but I would point out two main articles, and they might have a little contradiction between them. Our problem is there, okay? But I will tell you the last chapter of the soap opera, the last episode of this soap opera, is that we are dealing with this problem, and again, things are working here in Brazil in terms of commercial contracts. The first article is 317, and it says that judge can change the price when we have unforeseen and unforeseeable facts, etc. Everything that everybody said here. But the judge could change the price on these circumstances. And then we have the 478, Article 478. And this is a very traditional article, and it says that, well, the party, if we have unforeseen and unforeseeable circumstances or facts, the party can terminate the contract. So, and the judge cannot change the price or change the conditions. There is a tradition, a very strong tradition in Brazilian state court decisions that says that the judge cannot negotiate for the party. Okay, so it's a very strong tradition. Contracts, pacta sunt servanda, is very strong in Brazil in business law. Again, I'm not talking about consumer law. So what do we do with those articles? I should say that what we've been doing is, again, to see the case, the specific case. So we have a lot of tailor-made decisions. We will consider each market and then adapt the contract. There is a difference between negotiate for the party and to adapt the contract. And I may be wrong, but my impression is that state courts are adapting contracts. So we had, as I've said, a lot of injunctions, and then we have some discounts in this first moment. Lease contracts, energy contracts, mainly lease contracts for real estate. And we have some discounts from 30% to 50%. It depends. It was the first reaction of the courts of, I would say, individual judges. Okay, what we call the first grade. We have just one judge. And this was the first reaction. Another reaction was, as I said, curbing opportunism. And this was very important. In the first moment when there was chaos, terror, and panic, there's a strong behavior, there's a strong answer from our state courts was very, very important. And what do we do with those articles? Again, I may be wrong, but I would say that courts are just combining them, putting them together without so many worries about dogmatics and, well, the essential basis theory, etc., etc. Well, let's put together. We have unforeseeable facts. It's completely, nobody could predict them. They are unpredictable, of course. This is a consensus. And let's adapt the contract. And again, as I would say, I would quote Ripper here, because Ripper has been quoted a lot here in Brazil, to adapt the contract. It's not, at the end of the day, adapting the contract is keeping the contract. So we are dealing with pacta sunt servanda. Yes, in Brazil, we do respect contracts, business contracts, and then we are adapting them. The judges don't want, we have some strange urban legends here sometimes, here, no, all over the world, that judges love to negotiate for the parties. This is not truth. They don't want to do that. They want to apply the contract. And you said just the last thing you were saying about, you mentioned equity, justice, and equilibrium. The justice, the parties, we are talking about business. The parties know what justice is for them. They are the best judges of their own interests. I would say that this is not my opinion. This is state courts, Brazilian state court's opinion. Okay, that's it. Just the kickoff. Okay.
Perfect, Paula. Thank you very much for this insight, this profound insight. I think you mentioned 2 points that really make a lot of sense, and we worry much about it. How to bring to state courts some contracts that we have that are deal with people that are very knowledgeable of what we're doing when they contract. The contract is for sure not a consumer contract. The contract is not a simple contract at all. And I think arbitration helps a lot this, because when you have an arbitration, you put arbitrators who really deal with that industry, and they know what they're doing. They know what this contract means, the background of the contract, the whole network of contracts. And you also brought to our attention one problem that it's very present in today Brazilian law, is that is the judge able to intervene, to not negotiate, but to adjust, to adapt the contract, or he can only terminate the contract? And to terminate an engineering contract, to terminate an EPC contract, may have very, very dramatic consequences. And I think you deal very great with that, the principles behind it, and the possibility that we have to adapt, and how the judges are reacting in this pandemic, and give us a lot of comfort to know that the termination is not the only way out for the parties. Thank you. Thank you very much, Paula. David, I will go back to you once again. And I cannot say that you're a British lawyer anymore. You correct me exactly. So as an English lawyer, David, now bring us a little bit of the panorama in England. How does the English law and the English lawyers can deal with such an unforeseen event as the pandemic? Is there such a thing there? I think you mentioned a little bit, but is there such a thing as to adequate the contract by the judge? Can the judge do that in English? Is there such a thing of renegotiation the contract in face of a pandemic? Please give us a little bit of the framework of the English law and how the common law system deals with that. Is it the same? Is it very different from the civil law perspective? Please, your thoughts.
Right. You said I had 3 hours for this. Thank you very much. No, I have to go very quickly on this and perhaps leave out some key things. When I saw the topic and I was wearing my English lawyer's hat and I read Revisiting the Right to Contractual Negotiation, my first reaction was, well, which right? There's no such thing as a right to contractual renegotiation. Now, what do I mean by that? One of the striking differences, I would say, between English and French law is that English law is far less prepared to help the parties out in circumstances like these we've been encountering during the last few months. In fact, if you go back and you look at the history of English law over the last few hundred years, for many centuries the laws and the courts took the view that the parties' contract was sacrosanct. You don't touch it. You don't touch it. You don't change it. And even, can you believe it, the view was that a party would remain bound by the terms of the contract even if what it contracted to do became impossible. Crazy though it sounds, that was the position. Yes, things have changed. A lot of you will know about the notion of frustration. I would need an hour to go through this properly. So in 30 seconds, what on earth is this? It's an event that happens as a result of which one party says to the other, look, because of this, I can no longer perform the contract that I signed to perform. There's been a fundamental difference. But what's the outcome of this going to be? Do you go off to a third party, a court or somebody else? No, it's termination. It's termination. So, the protection at law is extremely limited compared to what the French law position that I mentioned earlier on. So, this is one of the reasons, one of the many reasons why you find that common law contracts and English law contracts, the contract terms are an awful lot longer than their equivalent contracts sometimes in civil law systems, because they don't have the fallback, what I sometimes call the safety net of the civil code. What I would say is that there is, and it's dangerous to generalize, so I shall generalize. There's relatively little English positive legislation on contracts. a lot of it, the law is made by the courts, and who knows whether your factual situation might get you in exactly the same situation as a court decision. So what do? You set everything out in the documents. Now, I say this knowing that very well. In the next session, you've got what the person I would call the king of collaborative contracts, David Mosley, who's going to talk. He may give you a slightly different view as to how the situation has been set out in terms of contracting in these contracts. But that's another matter. I'm talking generally about English law. So we don't have this regime. There's nothing. Set it out in the contract. If you've got nothing there, it's a very difficult situation. Now, why do we not have this sort of regime in English law? Again, not an easy one to answer very quickly, but I think it has a lot to do with what I would call an obsession with certainty in the English legal system. Certainty as to the application of all of the contract terms. So if you have a regime, a sub-regime in a contract providing for renegotiation in certain situations, then that is likely to be considered to be what is called an agreement to agree. And in English law, we don't like agreements to agree. It wouldn't be upheld. Very problematic. Now, that doesn't really stop you from actually putting into your contract this regime. The question is, how is it going to be applied? The judges and arbitrators applying English law will certainly try to apply it. They might be a little bit reluctant to do so, but there are English cases where matters which have been left to a judge to fill in a gap have been accepted by the English courts. So it's not a big barrier, it's not a big problem in principle, it's just a huge psychological hurdle to get over. It's just not the way the English do things. Another part of the reason for this, it's all linked in to the overall view of contracts. In most of the world, what I call the civilized world, the 150 civil law systems, good faith is a cornerstone of the system, which brings lack of abuse of contract terms and the whole notion of fairness. And in this context, it's far easier to see how the court comes in to support the parties. But English law and some other Commonwealth legal systems, but especially English law, I think, can still to some extent be seen as the Wild West. You have to look after yourself out there. So all I would say is, in concluding, I can understand very well how a lot of civil lawyers say, oh, I like English law because of the certainty. But then what they also say is that English law still has an awful lot of progress to make when it comes to situations like the one we're facing now. That's it for me for now.
Okay. Thank you very much, David. We're receiving a lot of questions from the audience. I have some from myself also. And I have now to ask Ricardo. Ricardo mentioned about the sharing of responsibilities, the sharing of extra costs in case of this adaptation by the judge of the contract. Ricardo, could you explain a little bit more to us how this theory, this doctrine of sharing efforts is in Argentina, how it's developed, how it's dealt by the courts, and especially which are the forecasts. So the owner will get all the extra costs, the contractor will have some of the extra costs, how they will split this in case of an unforeseen event, as we are seeing.
Thank you, Marcelo. Let me start by saying that at this point it's quite difficult to start making forecasts, precisely because we have not seen how, in general, how the courts react to the current circumstance. I liked Paula's reference to the Pacta Sur Servanda concept or Roman law principle, because it's a concept, and we forget this, but it's a concept that is supplemented, at least under the basic Roman law principles, by another concept, but which is rebus sic statius, provided things remain the same. So contracts must be complied with to the extent the circumstances that the parties had in consideration when the contract was executed remain the same. And this is precisely the concept that drives the excessive onerosity, the theory, the prévision, and other readjustment legal remedies in civil law jurisdictions. In Argentina, the shared effort doctrine is perhaps going beyond the excessive onerosity. We discussed earlier on that this theory d'imprevision basically seeks readjusting the contractual equation, bringing back some justice into the parties' remuneration or obligations. But the shared effort doctrine goes beyond this because it seeks to share the losses derived from a certain extraordinary event that basically distorted the contractual equation or even threatened to terminate the contract. As I said before, there's significant experience in applying this concept. It was developed first as a result of the economic emergency regulations issued by government and later on by courts as a result of the economic crisis that we suffered in 2001, 2002. It was initially thought to bring back equilibrium to financial contracts, for the most part loans that were denominated in US dollars, with payment obligations in the same currency after a massive devaluation of the peso. So you can imagine the situation of a debtor, someone who got a mortgage from a bank and all of a sudden owed the bank an enormous amount of dollars. There was no way he could pay that. So the courts and the government, to some extent, stepped in, and the concept was to seek to preserve the continuity of the contractual relationship in an equitable way. So this is important because as part of the administration of justice, something that is not usual, regular, at least in our jurisdiction, the Argentinian jurisdiction. The concept, as I said, even though it was developed to apply for financial contracts, can certainly be extended to other contracts to the extent the same extraordinary circumstances have extraordinary impacts on contracts, in this case in construction. So the first stage in this process is, a negotiation between the parties trying to find a solution situation. Again, not only bringing back to a normal levels the contractual equation, but also finding the way in which parties will absorb their losses resulting from the extraordinary event. In past years was, let's say, simpler to the extent you had to deal with the effects of a devaluation on a financial contract. But now the situation seems to be more complex because there are many other, in addition to the economical one, may have an impact. The main economic impact would be perhaps derived from the breakdown of the payment chain, as I said. But then you have additional costs derived from health and security protocols, the consequences of the delays, additional costs in importing, for example, products or equipment, and for the most part, an enormous amount of unpredictability and uncertainty that cannot be weighted properly now. We will have perhaps a clearer picture later on when the aftermath of this pandemic is accounted for. So, in my opinion, this is why, at least from my perspective, you should not look, or we should not look at approaches that dispense with the facts and the particular circumstances of the case. And these are the issues that the court will consider. We are not going to limit ourselves to restoring a contractual equation, but rather to seeing how we can bring equity and back to the contract, and how we can make the parties accountable for the contract losses as a whole, and not as the other parties' losses in particular. Perhaps this is a summary on how the courts will deal with this. You need, again, David mentioned that good faith has a major role to play in contractual interpretation and application in civil law jurisdictions. Argentina is not exception. There's a great influence of the need to preserve the contractual relationship and the existence of the contract against the termination of the contract. And, you know, the courts will probably evolve in that direction. The question is how and when the courts will actually start to issue rulings that will give us a proper idea on how these principles will be applied.
Thank you, Ricardo. I would like now to move a little bit to Brazil and ask a question to both Fernando and Paula. We are seeing here in Brazil a lot of discussion about some duty to renegotiate the contract in case of unforeseen circumstances. And for Fernando, I would like him to answer how the renegotiation of contracts and this duty are actually taking place. When we started this pandemic, as you all said, we have chaos and we have a lot of alarmism. And we thought the litigation would explode here in Brazil. The arbitrations would be in a huge number. And Fernando, could you comment to us if the litigation was so much as we expected? The negotiation didn't really happen. Parties are negotiating their construction contracts. And to Paula, if Paula could give us some thoughts about this duty to renegotiate. How does it operate? What are the sanctions? What are the consequences of not complying or fulfilling this duty? What could happen? What is the nature of this duty? Please, Fernando.
Okay, in the first weeks of the pandemic, when construction companies realized that they should implement a number of measures, as I said before, and besides, their productivity would fall dramatically. I was consulted for many of these companies about how to deal with their employers, because the first response of the employers was that they would agree with an EOT and station of time, but they would not pay for any extra cost, since they were facing a typical case of force majeure. But as time passed, like Paula said that after the chaos, panic and terror, I noted that has increased the general feeling, not only in Brazil, but worldwide, that we are before much more than a problem, much more serious than a simple incident in a contract, that more bigger than a mere legal problem. It's actually a global problem with a number of different implications in so many areas. And people seems more sensible to that. Then parties were progressively changing their behavior and making themselves more open to negotiate a solution that preserves in the first place the contract itself and the continuity of the project. I think it's a trend right now, this changing of behavior. If we observe the guidelines of FIDIC about the pandemic, and I asked permission to Aisha here to talk about FIDIC because she's the great authority in that. I will dare to talk a little bit about FIDIC guidelines with your permission, Aisha. They orient parties to use the provisions already stated in the FIDIC models, which means that FIDIC claims that all the answers are already there. And in almost every case, the provisions lead parties to an EOT, but with no financial compensation. If you take the EPC contract, for instance, all the responsibilities are located in the contractor. In the other models, they have the force majeure clause, the unpredictable events clause, but always leading to, almost always leading to an extension of time, but with no financial compensation. But in the very same guidelines, FIDIC says, and I will quote, I ask your permission to quote some parts of the recommendations of FIDIC. They say here, and I quote now, FIDIC would, however, remind its contract users that solutions to project difficulties are not only to be found within the four corners of any contract. Care should be given to the following. 1, impact of the governing law of the contract, as Ricardo mentioned before, decisions and recommendations from governments and authorities, and most important for me in this context that we are discussing here, social responsibility. As this crisis progressively impacts everyone globally, if every business shelters behind hardline and rigid approaches, this can lead to a booming escalation of insolvency cases with a severe knock-on negative social effect on societies at large. Another point, long-term versus short-term views. Little or nothing can be recovered from an insolvent business. Enforcing strict and rigidly contractual rights may not be in one's long-term interests, if that means bringing one's own supply chain to collapse. And the last part, as a corollary of the above, FIDIC encourages users to, I'll just mention 2 of them. 1, seek through cooperation, negotiation, and open dialogue, practical and realistic solutions to the challenges we are all facing together. And the second one, not only consider contractual and legal matters to handle their projects throughout this crisis, but also consider long-term business interests, social responsibility, long-term health of supply chains, and of societies at large. So we can see here in the FIDIC orientations, the guideline, that there is a concern about how we will deal with the problems in the future. What is the great consequences of this moment that we are living here? So this is not only a legal problem, but a social problem, a global problem, and we have to deal with that. So good faith, I think it's the basis of everything, because we have to defend not only the contract itself, but also all the consequences in the society that we have to be aware to how to deal with that.
Perfect. Paula, could you give us your thought about this duty to renegotiate the contract? I think you're still on mute.
Don't forget the mic again.
I do this every day, believe me. I agree with Fernando, and I would say that the idea is case-by-case approach. Okay, so some vectors here, some directives. First of all, case-by-case approach. Second, let's not mix consumer law and business law. You may be asking yourself, why is she saying this so many times? Because many of those theories are very adaptable to consumer relationships, not to business relationships. I would say that in theory, to say that there is a duty to negotiate or to renegotiate is a little bit too strong. I don't know if good faith goes that far. But I would say that, again, we have 187, Article 187 in Brazilian Civil Code, and the abuse of a right is forbidden. And you abuse of a right, the article says, when you use this right in a way that is completely not disconnected to good faith, to what we should expect from you, okay? And what Fernando said, what would be expected from you, considering that market, considering that environment, considering that specific situation. That's why case-by-case approach is so important. What I am watching here in Brazil, I think we all agree on this, is that I haven't seen a case in a big contract where a party says, no, I want this obligation this way, exactly this way, if the other party or the economy of the contract was impacted by the pandemic. So you have to prove the impact. This is the first point. We are talking about construction contracts. And of course, most of them, as Fernando, everybody said here, was strongly impacted by the pandemic. But there are contracts that were not impacted. Okay. So the first point is that you have to prove the impact. That's why, again, case-by-case approach. And then what happened in that contract, in that situation. And so I wouldn't say the things, okay, those phrases are very made to stick, okay? So if you say duty to renegotiate, it's nice, but I think maybe it's too strong. I wouldn't say we have a duty, the duty is good faith. The duty is against abuse of a right, exceeding the right, etc. And what I'm seeing here in Brazil is that parties, there is a trend to negotiation, okay? Nobody's fool, of course. We are talking about business. We are talking about big money because we are talking about construction. But I haven't seen much opportunism in the sense. Companies are negotiating and considering the effects of the pandemic on contracts in general, considering the specific circumstances. And this is very good. And what I see in state court decisions, even in and also in arbitration decisions, is that everybody is worried about the market. This is very interesting. Judges know that the single contract, or this is a public policy between commas and commas, inverted commas, in the sense that we have to think about the market relationships and about the whole environment. And this is good. I think people are taking care of it, or judges and arbitrators are taking care of it. We know that it's not a single case. The point is not a single case. The point is the market. The point is the economy. That's why I was so worried in the first time. Not only me, but everybody was so worried with that chaos, terror, and panic. Let's break down all contracts. Nobody's going to respect anything. Let's suspend all the obligations. And the president of Central Bank in Brazil came out to say, it will destroy economy. I just want to remember you, deputies, and these populistic ideas. The president of Central Bank said, I would like to remind you that will destroy us. Okay, we need remembering Adam Smith here. I mean, we had food on our tables, we had dinner, and that was because of contracts, and because contracts were respected, adapted, of course, but respected, and because we had the supply chains contract respected. That's the point, and I think that the president of our central bank was just perfect at that time, and we didn't have the chaos, terror, and panic that we foreseen at that time. That's it.
Great, Paula. Actually, I myself have been seeing a lot of contracts being adapted, even if they are not excessively onerous or impossible to bear, even though owners are calling contractors and trying to find equitable adjustment to deal with the pandemic. But now, moving forward, for the future, what to expect, I would like to ask David and then Ricardo. But first, David, the lessons learned. What do we expect from now on? What do we expect of the contract conditions we enter into? How they're going to change to face those unforeseen events that were never thought about us, for us. And the forms of contract, the FIDiC forms, for example. Aisha is with us, and she may be able to talk a little bit of this in her panel. But are we expecting changes in the format, the contract forms that we use?
Thanks, Marcel. Just a couple of words quickly. In the French contract domain, I haven't seen very much yet. Things seem to be going forward quite smoothly. There is, shall we say, a culture of renegotiation. Now, I'm not saying there's not a culture of renegotiation in England. I just don't practice that. I haven't seen it that much. What I can say is that some government bodies have been putting forward draft supplemental agreements to contracts for parties to think about. There's an entity called, and I've discovered this entity, called the Construction Leadership Council, which is coming up with new provisions to put into new contracts. One of these is to develop really the notion of a pandemic in a force majeure type provision, which would give a lot more relief to contractors. And this is not just for time, it's also cost, which raises interesting points, because it's for a long time, the idea of time but not cost has been a fundamental feature of contracts. And the fact is, well, the employer can say, well, I have no responsibility whatsoever. Why should I have to pay more cost? So that's going to raise interesting points there. So that's just what I've seen England and France. FIDiC now. FIDiC, how long have I got? Fernando very helpfully referred to the memorandum, which I recommend to everybody on the FIDiC website, came out in April 2020, which gives a very good review of everything that is available under the clauses in the new editions already. And he read out very helpfully some of the recommendations. The question is, can and should FIDiC go any further? What I was just listening to everybody, I was wondering, well, perhaps FIDiC can adapt matters quite quickly. We've just had a new set of contracts. We're not going to get a new set of contracts just because of COVID, I don't think. But in the past, FIDiC has been able to bring out proposed modifications to certain contract terms. Some will remember a memorandum that came out in, I think it was 2014, regarding the application of clause 20.1 on the notices and also the use of the dispute board provisions. Well, perhaps there would be scope for some sort of set of optional clauses which could address this. And I think we could think about clauses providing a renegotiation or adaptation regime. Why not? If they could fit in to the standard forms as they are now. This might be tricky because, don't forget, FIDiC, yes, is the most commonly used international contract, but still very much a common law based beast, if I can put it in those terms. So there's a bit of adaptation if you want to bring in adaptation. But why not? Perhaps Aisha will tell us tomorrow in her panel that there's already a task force set up for this, which would be very good news. And that's for me.
Great. Ricardo, let me ask you now a little bit of your experience and thoughts about what can be improved in our contracts, but not in the relationship of the owner with the contractor, but with the contractor with the subcontractors. Because in this construction industry contracts that we have, we all are facing now some difficulties with international furnishment of goods, of equipments, and sometimes our contract has a legal framework, but the subcontractor has another legal framework. How can we advance in such matters?
Right. Yeah, a lot has been said and written so far on the need to rethink contractual provisions dealing with force majeure. David was just mentioning the possibility of including optional clauses in fitting forms, and perhaps that is the case in other kind of model contracts. And perhaps there is a genuine need to revisit force majeure provisions. You made a point on the subcontracts, and I think that perhaps a key point after the lessons learned or the experience gained with the pandemic is perhaps trying to secure more consistent contractual standards concerning force majeure provision in projects that had multi-layers of contractual relationships. When you have the principal, you have a main contractor, you have a subcontractor, or vendors of key equipment, suppliers, and so forth. An example, a recent example in my case, you have a main contract subject to the laws of the jurisdiction of principal, right? Then the main contractor is a large international company. The main contractor hires a subcontractor and imposes a subcontract to acquire with a law of a different jurisdiction, of its own jurisdiction, let's say. Then there's an additional contract concerning the acquisition of key equipment, but the supplier of that equipment is also a large multinational corporation and imposes its own contract subject to the laws of its own jurisdiction. So, and then if you want, you can add the impact of other contracts, for example, shipping, right? That have their own formats, their own governing laws, and so forth. So all these contracts, at some point, have been impacted by the same extraordinary event on the global scale at the same time, with different implications. They have differing governing laws. They have differing standards in terms of force majeure provisions. And all of this may derive in a major contractual legal interpretation conflict. How will an arbitration or a court deal with all these potentially conflicting legal principles on exactly the same event? So, what my point is, looking forward, and especially in projects involving several parties in different jurisdictions, the focus should be to be more clear, more consistent in the need to secure a uniform kind of standard for key provisions like we are learning now, force majeure extraordinary events, in a way that the impact cannot be so extreme that we have seen now. There are lots of examples around the world on how the supply chain of major infrastructure projects has been dramatically disrupted precisely because there's a differing standards, legal standards affecting the same project at different contractual levels. The second point perhaps is how the main contractor and subcontractor relationship will be dealt with in times of emergency, and how risks will be allocated in those circumstances. We all know that the trend is to try to allocate as much risk as possible to a different party. That's the concept of an EPC, a traditional EPC contract. And when the EPC contractor subcontracts, it tries to do exactly the same with the subcontractor. But this is something that is wise doing. Are we learning something out of this pandemic? Are all risks subject to allocation the way we used to know? or we should provide for provision. We should include provisions providing for absolutely unforeseeable risks. David was just mentioning this as a possibility in FIDIC contracts, and I think would be guiding the contract negotiation henceforth in a very strong way. But perhaps the last issue that I see perhaps in this case is how the consequences or disruptions will affect directly, indirectly a given project, and how, if at all, a collaborative approach, which will be dealt with in the upcoming panel, could help to solve these kind of issues. We have been discussing throughout this panel on renegotiation, equilibrium, equity, sharing losses, and so forth. All this implies not only the notion of good faith, but also the genuine notion of collaboration, of cooperation, which is something that, in my view at least, is not present as it should be in our contracts today. And perhaps collaboration, cooperation, a different approach to contract execution would be helpful to deal with circumstances like the one we are dealing right now.
Perfect, Ricardo. I would have a lot of questions for all of you, but we are coming to the end of our panel, and I would like to take this last minutes and some extra time for us to see some questions that were made by the attendees of our panel. And one very interesting question, Paula and Fernando, that was raised here. I think you could both comment a little bit on that. Now we have a little time, but it's a very nice question. What will happen in the case of a judge, of an arbitrator, adjusting a contract because of a claim of a contractor, for example, and then the owner say, well, this contractor adjusted by you, arbitrator, this contractor adjusted, adequated by you, judge, I don't want it anymore. And then may I have, owner, a right to terminate the contract because of what the judge, the arbitrator, adjusted, adequated?
Again, I may start. Again, is a case-by-case approach. Again, what we can answer, what we can remember are our principles. Again, good faith, curbing opportunism, excessive onerosity, and yes, we have 478 and 317, those articles that I mentioned before. I may be boring, but I would answer, Marcelo, it depends on the case. Sometimes it's bad faith, considering an objective bad faith, not nobody's an angel. Again, we are talking about money, we are talking about big money, so we are not talking about sense or disconnected idea of good faith. Okay, I'm against what David said, this obsession for certainty, but certainty is important, and considering the market is important. So good faith, yes, but considering the specific circumstances of the case. Sometimes this refusal is an abuse. Sometimes it's not. It depends on the situation. And again, I haven't seen this yet, okay? What I see is adoption, and what I see is not this kind of opportunism. And again, what I see in state courts is those decisions that say, okay, we may adapt, but you cannot be opportunistic. That's what I would answer to this very good question, Marcelo.
Fernando, your thoughts?
I completely agree with Paula. Based in good faith, if the employer decided to ask for the termination of the contract because the contract was adopted by the judge, I think it was your question, depends of the good faith. If the judge adopted the contract just to make it balanced again, so what's the ground that the employer have to ask for the termination? Because the termination is because of unbalanced contract. But if the contract was balanced right now, so what's the ground? What is the cause that the employer have to ask for termination? So I think it's a typical case of good faith, and what have to be considered by the judge or the arbitrator is exactly this point. If party is asking something based on good faith or bad faith. Totally agree with Paula.
Okay. I have now two questions here. One for Mr. David Brown. David, we have a question from a fellow of all of us, a friend, Julio Cesar Bueno, who asks you, following the principles and applicable laws, a clause in contract establishing that no force majeure impact could ever be considered. Would this be stand in England and Wales law? What about French law, David?
Right. I'm doing a Paula, if I can say that. Very sorry. Thank you, Julio Cesar, for the tricky question. Again, to deal with this very quickly, English law approach, no force majeure impact could ever be considered. The question from the judge, if it went to a court, is, what do you mean by force majeure impact? Please give me a definition of what you're on about. And he might say that, you know, that sort of provision, I don't know what it means, so I can't really apply it, possibly. It's curious that in English law, I remember coming across one standard form construction contract, which said simply usual force majeure terms. And I thought that's very strange, because there are no such thing as usual force majeure terms. So not quite sure. So that one might not work too well in England. Would it stand in French law? Basically, no. Force majeure, like good faith, is a cornerstone of the system. If you don't have a valid provision for force majeure, then that means you could be required to perform the impossible, which is not possible. And I say a valid provision, what the French would say is it is a fundamental feature in the civil code. It is a matter of public policy, in other words. You cannot exclude it. So the answer is no. I hope that's clear. I'm trying to go very quickly.
Okay, Ricardo, a last question in your panel goes to you. In EPC contracts, with clauses that shift to the contractor all the unforeseen risks, it is expected that the contractor had a price that would face these circumstances. In a scenario like this, even in a pandemic scenario, would the judges and arbitrators in Argentina and with Argentina law would consider already that a little bit of the price has already been put aside, or at least is incorporated in the price, a little bit of the cost to deal with this extra costs regarding the pandemic?
Well, the question basically is aligned with what Paula said at some point, and I think David commented on this also. A FIDIC contract, as for the most part, and I will use David's own words, and it's not my own definition, it's David's. It's mostly a common law beast, and typically has problems when being subjected to civil law jurisdictions. One of the problems is precisely the relationship of on risk allocation clauses, severe risk allocation clauses, the legal principles concerning, as I mentioned, the theory de imprévision, excessive onerosity, or the right that parties have to achieve a contractual rebalancing if extraordinary circumstances occur. It's virtually impossible to foresee every single risk that may have an impact on the construction contract. And of course, it will be, as Paula said, a matter of case-by-case analysis. The court will have to analyze the case, the parties will have to prove the extent of the loss, of the extent of the impact, or and if the circumstances are the right ones, the court will certainly provide an adjustment of conditions or obligations. Again, contracts under Argentinian law and under most civil law jurisdictions must be negotiated, executed, and interpreted in good faith. And the principle of good faith excludes, by its own nature, the excessive or abusive exercise of rights, which means that a court would necessarily have to intervene if there is an evident disruption in the balance of the contract. So my reaction to the question would be, irrespective on what the contract says concerning the risk allocation, and let's assume it's an absolute risk transfer from one party to the other, the party suffering a loss as a result of the pandemic will have the right to ask a court on arbitration panel to rebalance that, and it is likely that, provided that the parties actually proves the extent of the loss, they will get a favorable outcome, at least partial outcome.
Okay, thank you very much, Ricardo. We exceeded a little bit of the time of our panel. So I would like now to thank very much David, Fernando, Paula, and Ricardo for their contributions here. You were a perfect panelists. Thanks a lot for being with us here in IBDiC, and one more time, and we expect to meet you all and in the 2021 event, the huge event we are having, David, with the ICLA. And so receive my gratitude and the gratitude from all of the peers of IBDiC. Thank you, my friends. Leonardo, now I pass the word to you, our master here of ceremony. Sound.
No?
Yes.
No, now you can hear.
Yes.
That's great, thank you. It's interesting to have this new role of Master of Ceremony. I'm not sure if I'm qualified, but I'm gonna do my best. Thanks a lot, guys. We already started strongly in this first panel. I would like now to go to a moment that is a very special moment of this event, because at IBDiC we decided that whenever we think that someone deserves recognition and a prize from IBDiC for all their work that they have done, we would do it. We are not saying that we are going to do that every year, but whenever we think that someone deserves to receive this recognition. Last year we did that with Mr. Jobim, he was very important for Brazilian law, and as an example of perseverance and other values that we very much appreciate. This year we would like to give the recognition of IBDiC and a prize from IBDiC for all their services that this person has been doing in construction law in Brazil. What I would say about this person: it's someone with initiative, it's someone with leadership. This person was very important in the last 10 years of construction, of work, of understanding, of dialogue on construction law in Brazil. this person also is an aggregator. He brings people together to achieve goals. He's an ambassador. He's someone that goes to events around the world, try to spread the word, to bring new ideas from Brazil. And he's also a very, very good friend, someone that everyone would be amazed to have a cup of wine or a beer with him. And I'm very, very happy to this year deliver this recognition of IBDiC to my very good friend, Fernando Marcondes. Fernando, I would like to be there to give you a hug in person, but we found some way that you get this person from someone else and receive this prize from someone that you love and we very much know. Camélia, please come in. Camélia is Fernando's wife. We would be clapping now, Fernando. Fernando, thanks a lot for all the work that you've done for years, okay? We are very, very much grateful for you. It's the floor is yours now, okay?
I'm totally surprised. Thank you very much. Thank you. I'm very emotional here. Camélia hide it from me totally. So I'm really surprised. Thank you. Thank you very much. I don't have words to say what it means for me. Thank you. Thank you, Leonardo. I think you have many people that deserve this kind of recognition, and I'm really proud to be the one this year. Thank you. Thank you very much.
No, Fernando, we thank you. Marcelo, would you like to say a few words too? Show the prize for everyone, Fernando. Just
yes. Fernando, great honor for us to participate in this moment. We were anxious to give you this prize. It's very, very well deserved. We all have to thank you for all the effort and all the lessons learned and all that you have been doing for the construction law industry and construction law in Brazil. Okay, receive our most profound admiration and thankfulness. Okay, we like to be with you. For a moment, you said to me that you were going to be in my office. That would be an honor to have you here at this day to give you this prize. Was not possible because of the pandemic, but please have a hug from me, a virtual one.
Thank you, Marcelo. Thank you very much. I'm really, really proud and really emotional here. Thank you.
And we will find some time after this situation get better, because we have to get together, everybody.
For sure.
We understand that these virtual encounters doesn't substitute all the heat of the personal contact.
I need to hug everyone individually because of that. Thank you very much.
That's great, everyone. Thanks, Fernando. Now, I would like to say a few words about the support that IBDiC and ICLA event is doing to a social cause. This year, we decided, because we are in a pilot event, a virtual event, we decided to have a free registration, but we encouraged everyone that would be part of this event to support Casa José Coutro. Brazil has lots of social challenges, and we believe we have to be involved in this as part of the society, of our community. We have to be involved in our community to help solving the problem. So we very much would like to say that we know the project Casa José Coutro, and that they are very serious and engaged in helping child and giving child support in Brazilian neighborhoods. So I'd like you all to see a small video from the Casa José Coutro that will show a little bit of their work. And for those who received an email from the committee with their account number, please help with what you can do. It's very important for us, okay? Thanks a lot. Giovanna, please, can you show the video?